And news coming in after 6 days of hearing the triple talaq issue, the Supreme Court has now reserved its judgment on whether the practice is constitutionally valid. Meenakshi Banja is getting us more details on that front. Meenakshi, first up, give us a sense of what really happened in court today. Have the arguments then wrapped up? Have both the sides presented their side of the story?
Well, that is correct, and not just today. This has been in continuum for over 6 days now, from the 11th of May itself, when the Constitution Bench convened again, which was very interesting given the fact that the Supreme Court is in the middle of summer vacations. But in spite of that, a specially convened Constitution Bench comprising 5 judges from different fraternities, which is so reflective of the heterogeneous society of India, were seized of the matter, where we heard some interesting discussions and debates take place. Of course, All India Muslim Personal Law Board's position is something which is very interesting. They have been opposing the Supreme Court's intervention into this issue. They have been telling the Supreme Court to keep its hands of making an order to strike down triple talaq as unconstitutional. That being said, what is very interesting is today, again, the Muslim Personal Law Board came out with its submission to tell the Supreme Court that they are considering informing the Qazis to inculcate a new subject in the Nikah-nama so that a woman can at the outset show her reservation for the invocation of triple talaq. However, this would not be binding. This is because yesterday Kapil Sibal was asked this particular question by the bench, if or not a woman have a right to say no at the outset during the Nikah-nama stage to triple talaq. So that was the response of Kapil Sibal, that the Muslim Personal Law Board would indeed be considering issuing advisory to the Qazis to inform the woman so that this can be inculcated in the Nikah-nama. That being said, what is very interesting is the might with which the central government has put its foot down before the Supreme Court. The central government does not want this issue to be adjudicated upon by the Parliament. And yesterday we saw the rejoinder arguments by the top law officer of the Union, Attorney General Mukul Rohatgi, when he made a very strong, determined pitch before the Supreme Court to ask them to strike down triple talaq as being unconstitutional. His primary focus was on point that this is not a minority versus majority issue. This is a problem which is within the community itself, where male are given superiority as compared to women in the community, and therefore it is unconstitutional, and the Supreme Court cannot look away when something which is so morally right is being made out morally wrong, beg your pardon, is being made out to be legally right. How can that be legally right which is morally wrong? That was the union's primary focus.
Actually, importantly, the centre did talk about the fact that triple talaq, is not a basic and integral part of Islam, and doing away with it is not essentially going to shake the foundation of the religion, and that's the real basis of the argument of the centre, isn't it?
Well, that is correct. That was the focus of the Government of India's position as to how this particular practice has been banned and abolished in several Muslim countries where they are looking towards making progressive steps into the future. Then how could India still be in the midst of such a retrograde practice? And the fact that something which is so morally wrong, how can that come out to be legally right? And like you pointed out, the attorney has said that this particular practice is not integral to Islam, and therefore it is not protected under Article 25-26 of the Constitution, which allows citizens to practice their own religion. But what is very interesting is this particular position has been as hotly opposed by the All India Muslim Personal Law Board, which wants the top court to keep its hands off the issue. They say that the reform has to come from within, and that is the reason we're seeing this particular movement today, where the Muslim Personal Law Board itself is telling the Supreme Court that they will consider issuing an advisory to the Qazis in order to inculcate or incorporate a particular point in the Nikah-nama where the woman can have a position to say that she does not want this particular aspect of triple talaq invoked against her. But that particular advisory, again, is not going to be binding. So this is a matter which is very layered. This has many nuances, and it is complex from whichever side you look at it. The primary focus here is whether the Supreme Court will intervene and strike it down as unconstitutional. This is something that we will all be waiting for when the judgment is pronounced. The order has been reserved just moments back. The 5 judges will take some time to deliberate upon all the arguments that have been advanced before them, and therefore what we are expecting very clearly is a judgment post summer vacations in the Supreme Court.
All right, Meenakshi, tracking all of those details. Thanks for the moment for joining us. Well, let's now also listen into former Law Minister and Senior Counsel Salman Khurshid, who challenged the practice in court.
Essentially, the focus remained on what is the fundamental area that Shariat occupies, and whether triple talaq is an integral part of Shariat or of personal law. There are two views there, and there have been several competing views as far as the four schools of jurisprudence are concerned. The court now has to decide whether it will harmonize, as I suggested to the court, that you must harmonize different views so that there is one acceptable view available for the courts in our country, as in the case of the judgment that was passed by Justice Badr Ahmed as a judge of the Delhi High Court. I have suggested that this harmonizing effort has to be undertaken, whereas the Personal Law Board has said that the harmonizing effort cannot be done by court and should not be done by court. They've suggested legislation. I have said that if something is part of personal law, then neither legislation nor courts can interfere. But if legislation is permissible, if it can be removed from practice by way of redrafted nikah namas, then it can't possibly be a matter of faith. You can't contract out of faith, just as you can't legislate out of faith. So I think that there is a little distance and difference between the Personal Law Board's opinion and mine, and some of the other parties are even further away. Now it depends on what the court will accept.